In the early hours of a Saturday morning, a line was crossed, not with a speech, not with a vote, but with silence. A foreign leader was seized. U.S. military force was unleashed. People died inside Venezuela, and the branch of government designed to decide when America uses force. Congress learned about it later. That is not a footnote. That is the story. Because this is how constitutional power disappears in modern democracies. Not through tanks in the streets, but through precedents no one bothers to stop. I want you to understand something clearly. This moment is not about Nicolas Maduro, and it is not even about Donald Trump. It is about a Congress, including Republicans, that is slowly accepting a smaller role in governing one crisis at a time. If you care about who actually holds power in America, this should unsettle you. So before we debate legality or tactics, we need to ask a more fundamental question. What does Congress believe its job still is? And that takes us to the core of the problem. What happened in Venezuela forces us to confront a question Americans tend to avoid. Not whether the president acted boldly, but whether anyone is still willing to say no. On paper, the system is clear. Congress holds the power to declare war. The president commands the military. Each checks the other. But in practice, that balance has been eroding for decades. And what makes this moment different is not the raid itself, it is the reaction to it. Republican leaders were not briefed in advance. Some were surprised, some were quietly uncomfortable. And many strikingly shrugged. They offered reasons. Some said Congress cannot be trusted with sensitive information. Others argued this was not really a military action, but law enforcement. Still others said the signs were obvious. Anyone paying attention should have known. Taken together, these are not excuses. They are signals that Congress is redefining its own role downward, from a co-equal branch of government to an audience waiting for updates. And once lawmakers accept that posture, the consequences extend far beyond Venezuela. Because the real issue here is not what the president did. It is what Congress allowed to become normal. And to understand how we arrived at this moment, we have to look backward, not to Trump, but to history. To see how we got here, we have to step back far before this raid, far before Donald Trump. The modern American presidency has been expanding for more than half a century, not in one dramatic leap, but through accumulation. The turning point was Vietnam, a long war fought without a formal declaration that shattered trust between Congress and the White House. In response, lawmakers passed the War Powers Resolution of 1973, an attempt to reclaim authority to force presidents to consult Congress before and after using military force. On paper, it was a reset. In reality, it became a ceiling rather than a shield. Presidents of both parties learned how to operate around it. Briefings replaced debates. Notifications replaced permission. And every possible instance became a phrase flexible enough to mean almost anything. Over time, Congress adapted not by resisting, but by adjusting expectations downward. If troops were not deployed long term, it was acceptable. If casualties were limited, it was tolerable. If the action was framed narrowly, it was survivable. This gradual shift normalized presidential initiative and legislative passivity. So by the time Venezuela happened, the system did not break. It behaved exactly as it had been trained to behave. And that brings us to the first real stress test of this logic, the moment where justification met consequence. The first real crisis came not with outrage, but with explanation. After the operation, lawmakers were briefed not before, but after. The Gang of Eight met, questions were asked, and the administration offered its rationale. This, they said, was not a war. It was an arrest. Yes, the U.S. military was used. Yes, force was lethal. But the goal, they argued, was law enforcement, the execution of an arrest warrant against an indicted individual. That framing mattered, because if this was policing, not war, then Congress did not need to be consulted. No vote, no debate, no permission. Some lawmakers accepted that logic. Others hesitated quietly. A few objected openly, asking why key committees were excluded, especially when a foreign head of state was delivered to an American courtroom. This was not a small technical dispute. It was a precedent-setting moment. Because once military force can be reclassified as law enforcement, the line Congress is meant to guard begins to blur fast. If you're trying to follow this, you should pause here. Because what sounds like a legal nuance is actually a power shift. And that shift leads directly to a deeper question, not about process, but about authority itself. Beneath all of these arguments lies a quieter, more consequential idea that presidents possess powers, not clearly written down but assumed, inherent authority. A phrase that sounds technical, almost harmless, and yet it carries enormous weight. The Constitution gives Congress the power to declare war. It gives the president the role of commander-in-chief. But it does not spell out every scenario modern leaders will face. So over time, presidents have claimed the right to act first and explain later when American lives are said to be at risk. That logic surfaced again here. The raid, some argued, was justified because U.S. personnel were protecting themselves while executing an arrest. Deadly force, in this view, was defensive. And defense, under Article 2, falls within the president's inherent power. But notice what this does. It shifts the debate away from Congress entirely. The question is no longer whether lawmakers approved an action. It becomes whether the president's lawyers can frame it as protection against an imminent threat. Once that standard is accepted, consultation becomes optional. Oversight becomes retrospective. And constitutional balance turns into interpretation controlled by the executive branch. This is the hidden mechanism at work, not defiance of Congress, but replacement of it. And when that mechanism is tested against reality, against facts on the ground, cracks begin to appear. That brings us to the second crisis point. The second crisis emerges when the justification meets reality. To argue that the president was responding to an imminent attack, you have to accept a specific premise, that Nicolas Maduro is a narco-terrorist, and that the drug trade itself constitutes an immediate assault on the United States. That claim is powerful but also deeply contested. Americans are not passive victims in this equation. They choose to buy the drugs, and the substances killing the most Americans today are opioids, not cocaine. So the idea of an imminent foreign attack begins to strain. This matters because imminence is the legal hinge. Without it, inherent authority weakens. With it, almost anything can be justified. The administration has also pointed to limits. No long-term U.S. troops were placed on Venezuelan soil. Under the War Powers Resolution, that distinction matters. The 60-day clock may never start. And yet, U.S. naval forces remain in the Caribbean. The military footprint did not vanish. It shifted. This is the danger of narrow definitions. When war is redefined as something smaller, shorter, or cleaner, it becomes easier to repeat. And repetition, not scale, is what reshapes power. Which brings us to the people most affected by these abstractions, not lawyers, not lawmakers, but ordinary citizens. For most Americans, these debates feel distant, abstract, legal, but power does not disappear in theory. It disappears in your life. When Congress steps back, decisions move faster and farther away from you. No hearings, no public debate, no moment where your representatives must explain why force is being used in your name. You are simply told it was necessary, and maybe it was. That is not the point. The point is that you no longer get to hear the argument before it happens. Only the justification after. If you are a parent, this matters. If you pay taxes, this matters. If you believe democratic consent is more than a slogan, this matters. because each time Congress stays silent, the threshold for using force drops. Each time it accepts emergency logic, that logic becomes permanent. You may not feel the impact today, but you will feel it the next time a crisis is declared, and the next, and the one after that. So the question is not whether this action was legal, it is whether you are comfortable living in a system where legality is explained, not debated. If this unsettles you, it should. And it's worth asking who still speaks for you when Congress chooses not to. And from there, the consequences extend well beyond America's borders. What happens in Washington rarely stays there. When the United States uses military force without clear congressional backing, the world notices not just adversaries, but allies. For decades, America has argued that its power is restrained by law, that it does not act on impulse, but through institutions. Congressional oversight was not a weakness. It was proof of legitimacy. When that oversight fades, so does credibility. Other governments draw lessons quickly. If the US president can act first and explain later, why shouldn't they? If military force can be reframed as law enforcement, why draw lines at all? This is how norms erode globally, not through declarations, through imitation. The Venezuela operation also blurs another boundary between justice and force. When arrest warrants are executed by militaries, international law enters uncertain territory. Extradition becomes optional. Sovereignty becomes negotiable. And for regions already unstable, that uncertainty spreads. A naval presence in the Caribbean is not just symbolic. It signals readiness, and readiness invites response. Power is contagious. So is precedent. The question is no longer what this means for Venezuela. It is what it teaches the world about how America now chooses to lead. And once that lesson is learned, it cannot be unlearned. Which leaves us with the hardest question of all, where this path leads next. Looking ahead, there are three paths this moment could take, and none of them are abstract. The first is the optimistic scenario. Congress reasserts itself. The War Powers Resolution vote forces a real debate. Lawmakers, including Republicans, decide that institutional authority matters more than party loyalty. Oversight is restored, not perfectly, but meaningfully. Emergency powers return to being exceptions, not habits. The second path is the most likely. Nothing dramatic happens. The vote fails again. A few speeches are made. Precedent settles quietly into place. Future presidents of both parties cite this episode as justification. Congress continues to complain, but not to confront. Power keeps drifting, one incident at a time. The third path is the dangerous one. Emergency logic expands. Inherent authority becomes the default explanation for force. Military action grows easier to initiate and harder to question. And eventually, a president pushes too far not because the system encouraged restraint, but because it no longer requires it. History suggests systems do not collapse all at once. They hollow out gradually, legally, with consent. Which path America chooses will not be decided by this raid alone. It will be decided by whether Congress still believes it exists to say no. And that brings us to the final question, not about law, but about responsibility. We often imagine that the greatest threats to democracy come from strong men who defy the law. But more often, they come from institutions that stop defending it. What happened with Venezuela will be remembered, if at all, as a tactical success or a legal argument. But its lasting significance lies elsewhere. It showed how power now moves in America, quietly, efficiently, with minimal resistance. Congress was not overruled. It was bypassed and then accommodated the bypass. That distinction matters because constitutional systems do not survive on text alone. They survive on habits, on friction, on the willingness of one branch to slow another down. If lawmakers decide that their role is merely to react, not to authorize, then the balance the founders designed becomes optional. And once optional, it eventually disappears. So the question is not whether this president went too far. It is whether the next one will go farther. If you believe democratic accountability still matters, this is not the end of the conversation. It is the beginning. Pay attention to the next vote, the next crisis, the next justification, because in the end, the erosion of power is rarely announced. It is accepted.